Welcome to Navigating the End of a Marriage.
Hello and welcome to Navigating the End of a Marriage with experienced divorce attorney Anne Moody Johnson. Anne is dedicated to helping clients navigate the challenges of separation with professionalism and compassion. I am your host, Kevin Rosenquist, and today's episode is Fair Division, the process of separating assets and debts in a Missouri divorce. Anne, welcome back.
Thank you. Good to see you.
To start, can you explain the general process of property and debt division in a divorce in Missouri?
Certainly. So in Missouri, the standard is equitable. That just is fancy nonsense language for fair. Most of the time, judges are going to decide that marital property and marital debt are going to be divided 50-50. And I mean, it's very, very much 50-50. So what is marital property? What is marital debt? Anything that is property that was purchased through your labor, anything that is debt that was acquired other than student loan debt is typically considered marital debt. So your 401k, your pension, these are obtained with your labor. They are split 50-50 if it was during the marriage. If it was something you inherited during the marriage, then that is typically non-marital unless you did something really ill-advised and made it marital. So let's say you inherit a house from a family member, and then you go and you get a loan so you can renovate this house and then turn around and rent it out. Your additional investment in this inherited home is now going to be marital, and the judge has to decide what part of the value of this inherited house is marital and what part is non-marital. And that can start to get a little bit hairy. We really try and advise people when they inherit property or bring property into a marriage that they really do try to keep it separate if they don't have any kind of a prenup.
And does the timing of filing for divorce affect the division of property and debt?
No.
Okay.
It does not. In Missouri, property and debt are divided as of the date of trial. So you can have a divorce pending, and that, extravagant vacation that the other spouse put on their credit card, guess what? That's your debt too.
Oh, good to know.
Yeah. I mean, the parties can agree in writing that they use a different date to value property and debt, but otherwise, without an agreement to the contrary, it is the day of divorce. So it is the day of actual trial. So yeah, you're plugging away at your job and you're socking money into your retirement thinking, okay, this is important for me. Well, your spouse is getting half of it, or it's at least being counted against your share in the half if the judge doesn't actually divide it. Yeah,
okay.
People are very shocked to learn that.
Good to know. No.
It's an unfortunate fact of Missouri law. People really do think, most of the time people think, well, we've been separated for years.
Right.
And sometimes somebody's bought another house.
Yeah, or car or whatever. Yeah, totally.
Cars are very common. People trade for a new car.
That's a dopamine hit, right? And you get to buy a car, like it might help you feel a little better if you're going through a divorce or separation.
So, but it really is the judges really do try and do a 50-50 split, and they'll make a grid of here's all of the property, here's all of the debt, and they try and split it up as close to 50-50 as possible. And then when it's not as close to 50-50 as they possibly can, then they'll make one of the two of you buy the other one out of the remaining whatever is left that they couldn't do with property and debt.
When it comes to assets acquired during the marriage, how does the Missouri law determine when those assets are considered marital property for division purposes? Is it all considered marital property?
If it is purchased with marital funds, so money you earned at your job, or you invested in stock with money that you earned at your job, and then you sold that stock and then bought something with it. Yeah, it's marital. It doesn't matter who actually earned the money. That is not a consideration at all. It is marital property, and it is considered the norm to separate it 50-50. There's virtually, not always, but it's virtually unheard of to see something other than a really boring 50-50 split. Just entirely too much thought that would have to go into it, and accountability and justification to do something else. And there really isn't much leeway granted under Missouri law. It's just, now there's quite a bit of leeway in determining what is marital and non-marital when things are commingled. like the scenario I gave you previously about the inherited house.
Right.
Some judges will take to the dollar of exactly, okay, let's say you came into the property with already owning a house instead of inheriting it. Or let's say you inherited a lump sum of cash. Let's say you inherited 50 grand. And then you use that 50 grand for a down payment on a house. Some judges will say 50 grand is non-marital. I don't care about inflation. I don't care about the increase in value in the house. You put in 50 grand, you're getting 50 grand. That's it. Some judges will say, I don't care, you commingled it, it's all marital.
So it really is up to the judge, huh?
Yeah, there's a lot of leeway on determining whether something's marital or non-marital once you've mixed funds. But as far as cutting it off once it's been determined to be marital or non-marital, yeah, if it's non-marital, it's going to go into the spouse who had the non-marital property. If it's marital, it's 50-50.
And I think that's interesting too, what you said, because like it's money, if it's money you made through your job, because a lot of people, have separate accounts. A lot of married people have separate funds. I know a lot of people who do that. A lot of people like us, we combine our stuff, but I totally understand it. And I could see people thinking, no, we have separate funds here. I paid for this. It should be mine, but that's not the case.
That is absolutely correct. Yeah. And who actually paid for it, who actually went out and acquired that debt is not relevant to this.
And if one one person works and the other one doesn't work, still doesn't matter, right?
Does not matter. No.
Okay.
I mean, the courts assume you were providing value to the marriage and the household, and probably raising the kids and keeping house and maybe managing the finances while the other
paying the bills and doing all that. Yeah, for sure.
Right. We just generally do not concern ourselves with that at all in Missouri. And it really does frustrate people because they think it should be different.
Right.
It just isn't. But
all right. So we've talked assets. What about debt? How does debt, to get divided that when it incurs during a marriage? Debt
is the same. It is split 50-50. The debt that is incurred during the marriage, like I said, the one type of debt that really is not is the student loan debt. Typically goes with that parent and isn't usually assessed against them as the other parent or granted anything the other parent, and the parent who gets it doesn't get some benefit of it in their 50-50 debt split. But debt also typically goes, if there's a lien on an asset, the debt typically goes with the asset. So if one person is granted a house or a car, they usually are assessed that debt too. If for no other reason they have a vested interest in making sure it gets paid. That is usually how that is done. But then again, at the end of the day, we want it all to look like a 50-50 split. So somebody may get more debt than the other one, and that's part of the buyout calculation as well.
Okay.
Normally when we're doing an uncontested divorce, if you're the person whose debt the name is in, for the most part, you want to make sure that it's getting paid. So we try to put as much debt with the person whose name it goes into as well. But it doesn't always work out that way.
Yeah, sure. Yeah, because if you want to try to do an even split, that doesn't always, depending on where everything is.
And then also of note is that a bankruptcy is going to stop your divorce debt in its tracks. So if you file for bankruptcy, the bankruptcy court prohibits the divorce court from proceeding on the divorce until the bankruptcy is over. So the divorce court cannot deal with the property and debt until that proceeding's finalized.
Interesting. Okay.
Yeah.
All right. And can property and debt division be finalized before the divorce is officially complete, or does it have to occur after the divorce is finalized?
So typically it's done at the same time. That's one of the things that the judge is ordered to do at the time of the divorce decree, is make sure that all property and debt is divided. Sometimes something will get left out. Sometimes a legal description is wrong, and there's ways to go back and fix that if something was in the error or it just didn't get included, which, like I said, it does happen. So there are ways of fixing that aren't super complicated. That's about the only time where we do that. Every now and then you'll have a case of fraud where somebody left some information out and they have to go back and deal with that then. And that's a much more nasty situation, but
I'll bet. So that was actually going to be my next question. I'm curious about if somebody tries to hide assets, before a divorce process, maybe they're husband or wife or spouse doesn't know about something and they want to keep that protected. What happens if they're caught?
If they're caught, then that's one of the rare occasions where you might not see a 50-50 split. Or alternatively, the hider is going to get slapped with the other spouse's attorney's fees, or some of them.
Oh, wow. Okay.
Courts definitely punish the person who's hiding stuff. It's just generally not a good idea.
What if they're found to be hiding something after the divorce has already been finalized?
It depends on how late it is. If you're looking at less than a year after you find out, then yeah, you could go back and reopen the divorce for fraud. But after a year, you're going to have a really hard time doing anything. Yeah.
Does that happen often where people hide stuff in your experience?
It doesn't. People typically are either married so little in time that there's not been time to hide anything, or they've been married so long that they know their finances pretty well. It's when it tends to be more in situations where somebody has been kind of abusive that they hide stuff. But even then, it's harder to hide stuff than you think, unless you are a multimillionaire with a business and you've got income streams of all sorts.
Right.
Normal people with a job have a check, it comes in, and we're going to see where it's going out. So if there's, $1,000 a month just disappearing out of this account, well, where's it going? If you're transferring it or writing a check somewhere, we're going to see where it went because we can see the deposit in exchange, so we can track down where it went.
So you're saying it's unlikely that my wife is hiding assets from me?
Probably not.
Let me get her in here. No.
Most people just don't live that large anyway that they can be hiding big assets. So
it would be tough for either of us to hide anything from each other. I could say that right now.
And the very wealthy people who have the ability to do that often have prenups. So
that's true. That's true as well. What's the point of hiding? Yeah. Right. What about if there's debt that one of the parties didn't know about?
I think that actually happens more often.
Than
hiding assets. Is they are surprised to learn that a party has been, blowing up credit cards.
Yeah, that there's a credit card they didn't know about or something like that, and it's got a huge balance on it. How does the court handle that?
I mean, if they just didn't know about it, and it really is going to depend on what they're spending on it. If they're just buying normal stuff and they didn't know about it, nothing, it's just going to be part of the 50-50 split typically. If somebody has a gambling problem though, or somebody
shopping addiction or something like that,
spending money on a significant other and racking up debt that way, then that can certainly be dinged as a negative, and that may adjust the 50-50 scale.
So if you're spending money on your boyfriend, then that's a no by the court.
It's a no. Yeah, don't do that. Or at least not significant amounts. Just keep it in check.
Just make sure it's an even split. Yeah. Is there a specific timeline for when property and debt division must be finalized, or is it just sort of like it all kind of happens at the end at the same time?
It all happens at the end at the same time in Missouri.
Okay.
But again, we can say, okay, we're gonna do it at a different timeline, but there really isn't any point in doing it at a different timeline unless you have custody issues that maybe you can agree on the property and debt, but you can't agree on the custody issues. So we can go ahead and have an agreement on this one issue that resolves all the property and debt issues while we're still working out the custody issues or the child support issues.
Right.
And so you might end up with a trial on part of the case, but not all of the case. So you could actually resolve that earlier in the case if you were able to. It's just not frequently done. I actually typically see, if I'm going to see one or the other, it typically is the reverse, where the parties are able to agree on the custody stuff a little earlier than they are on the property.
Yeah, I could see that. If anyone's listening who knows they're going to be going through a divorce and maybe you want to come see you or another lawyer, when it comes to the property division and the debt division, what do they need to be prepared with? What do you recommend people come to you with as far as documents, as far as information that makes the process smoother?
Okay, so deeds, a current statement of what is owed on any real estate that you have, latest statements of any debt that you've got, VIN numbers for the vehicles. If you've got the titles handy, that's great. If you don't, I'll still need to know whose names they're in. It doesn't impact the division. People think that whose title somebody's name is on, or it's like a car title, like, oh, well, that's his car. That's not how this works.
Yeah.
It's still part of the calculation. We still got to deal with it. But we have to know at the end of the day, even if, he's getting what you call his car, is it actually only in his name? Because that's going to show up on your property taxes next year if we don't get your name off of it. So
good call.
we got to do that sort of thing. So bring in your titles if you've got them. Bring in your latest plan statement for any retirement accounts you've got. Show up with everybody's social security numbers, everybody's dates of birth, including your kids. Those are the main things that people have. If you've got businesses, then that's a whole another matter. So you're typically showing your tax returns for those businesses and any kind of valuations that may have been done for those businesses. That's where we start to get very much more complicated than a standard divorce, is where we've got a business. Most businesses are small businesses and people have a good idea of what they're worth. So they don't have that kind of thing. But in the unlikely event that you've got a large business to sever, then we're going to have a business valuation of what we're about to go.
Well, to your point earlier too, if you have a huge business like that, probably a prenup exists, right?
Correct. If one of you came into the marriage with the business, yes.
Right. Yeah, true. Good point.
Right.
Good point.
If the business was started during the marriage, then that's a different matter. Although there are prenups that can cover that as well. So those are the big things. If you've had an appraisal done on your home recently, bring that, especially if you've had this home for a long time. People think they know what their house is worth, and they frequently are incorrect, especially if they've been in it a long time, especially a house that's paid off. It's like people have no idea what their houses are worth.
Right. Totally.
We usually do have to get an appraisal if they've been in a house more than 5-10 years.
Yeah. Makes sense. All right. Well, good tips as always. Thanks, Anne. And thank you all for tuning in to Navigating the End of a Marriage with experienced divorce attorney Anne Moody Johnson. For more information or to connect with Anne, you can visit AnneMoodyJohnson.com. And again, that is ANNE. And be sure to hit that like and subscribe button and leave us a review in the comments. We always appreciate it. Anne, I appreciate you being here. Thanks again.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.